welcome to another live session of Franchising with FASA. Joining us today is Esmari Jonker from Smit and Van Wyk. We are going to be discussing the topic about franchise agreements and the implications, especially with this pandemic and the lockdown and how it's disrupted everybody's lives. I mean, people have now lost incomes, people have had to close their businesses, they couldn't operate. And if you're in a situation where your business has been locked down and where things are happening, and especially when you've got commitments to landlords and commitments to say your franchise, especially in the franchise sector, lots of things can go wrong. And sometimes it's easier for us to avoid things than to face things head on. Let's ask legal how to best deal with obligations and commitments that we have agreed to with good intentions, never expecting anything like this ever to happen, a world shutdown. So hello and welcome, Esmari. Thank you for joining us today.
Hi, Romani. Thank you very much. It's good to be with you today.
Good. So quickly, before we start, Smit and Van Wyk specialize in intellectual property law, patents, designs, trademarks, copyright, licensing, franchising, and related commercial aspects. Esmari Jonker also sits on the membership committee for the Franchise Association. So let's get started asking some questions. What are the obligations with regards to the franchisor's obligations and the franchisee's obligations and commitments? What are the rules, the responsibilities, the commitments? How does it work?
Romney, I think all franchise businesses, they were exposed to severe difficulties and unforeseen circumstances caused by the COVID-19 pandemic. Now, if we have a look at the problems or the trading difficulties, it is very important that the franchisor and the franchisee work together. The franchisee, yes, like you've said, they've got obligations in terms of the franchise agreement to operate the business and to be involved in the business and to trade. Whilst on the other hand, you've got your franchisor who is the custodian of the franchise brand and who needs to protect the brand. When the parties are faced with trading limitations or restrictions in terms of government regulations, it has been caused as a result of no fault by any of the parties. And it is very important when you are faced with situations like this, which you did not foresee or which you did not even address in your agreement, what are you going to do if there is a pandemic? Then it's very important that the parties discuss what are they going to do. The parties should identify the difficulties. They should acknowledge and admit what can they do, what they cannot do, what are the restrictions, and how are they able to overcome their restrictions. For example, the business system may change, or they may adopt a business system. If you have, for example, a system, a restaurant, a sit-down restaurant, the parties may decide, let's do online orders, let's do delivery orders. But that will have a direct impact upon the business system as described in terms of the franchise agreement. So the parties can sit together, they can discuss, and they can see how they can overcome difficulties. If they need to make changes to the business system to, for example, generate more income or to enhance trading amidst the limitations or the restrictions, it's very important that the parties then record that interim arrangement or perhaps permanent amendments to the business system. So in other words, if there's an existing business system and changes will be made to that business system, it is important that the parties then agree whether they're going to have interim amendments or changes or whether they will adopt permanent or long-term or medium-term changes. And then those changes should be agreed upon, and then the parties should then be certain what they've agreed upon and be certain in terms of the specific changes which they have agreed upon to overcome the trading difficulties.
Now, when it comes to landlord agreements, how does one get help for that, or what should one do or think about? Because obviously, you know, the landlords need their money. They obviously got commitments and bills that they need to pay, but, you know, and the rent has to be paid. How does this work with regards to where people find themselves in situations where they're not operational?
So in terms of South African law, we need to have a look at the relationship between the parties, the franchise agreement, which will primarily govern the relationship between the parties. If the franchise agreement makes provision for a force majeure instance, or if there's a situation where the agreement explains what you need to do in the event where the parties may not be able to perform as a result of no fault of their own, one have to look at the agreement, and you need to determine what does the agreement say, how are we going to regulate, or how are we going to address this issue. If the agreement is silent on this, we need to have a look at the law of contract in terms of the common law, and in our law we refer to it as supervening impossibility. In other words, the parties are not able to perform as a result of no fault of their own. So we need to consider, first of all, your franchise agreement. Then we also need to consider your lease agreement in terms of whether there are specific provisions related to force majeure, and if not, then we rely upon the common law supervening impossibility principles, which will apply. But it is very important that you look at the specific circumstances. You also need to have a look on the restrictions. Are you restricted in terms of your lease or in terms of your franchise agreement to only do one specific portion of your business? Or are you restricted not to do anything? You can't do anything at all. And one needs to have a look at the specific circumstances, then evaluate it based upon your agreement, and then make a decision on what can you do to limit your own damages, and what can you do and negotiate and communicate with the other party towards whom you may have a payment obligation towards. Romani, it's very important. One should keep in mind that the fact that there may have been a state of disaster declared in our country, all relevant legislation still remains in place. So in other words, if you have signed a franchise agreement, or if you're going to enter into a franchise transaction, it's important to make sure, franchisors and franchisees, to remember that the parties are still bound to the legislation and to the ordinary principles which will apply to the relationship. In other words, if a franchisor is going to enter into a franchise transaction, the franchisor should still supply and provide the franchisee with a disclosure document and with a franchise agreement as prescribed in terms of the Consumer Protection Act. So although we may be in the middle of a disaster or in the middle of a pandemic, the parties are still subject to the legislation and to the normal principles or legal framework which will apply in as far as franchise transactions are concerned. So if we have a look on what financial information should be provided to a franchisee, we know that the Consumer Protection Act states that each and every prospective franchisee should be provided with a franchise disclosure document by the franchisor. And in the disclosure document, there should be financial projections. Likewise, in the franchise agreement, the franchisor should set out the total investment required by the franchisee, or what is expected to be paid by the franchisee in terms of initial and ongoing payments. So if we have a look at financial obligations, even though there's a pandemic, one should consider this as well. Franchisors should have a look at their financial projections in their disclosure documents, and they should also have a look at the financial obligations in their franchise agreement. And one should align this with projections and with payment or financial obligations now when we are in the middle of a pandemic, or when we are subject to certain restrictions or trading limitations. In other words, if financial projections are provided to a new franchisee, I would recommend that the franchisor states whether those projections are pre-COVID, and then also provide an indication of trading figures or trading activities in the middle of COVID. It would not be correct to provide the franchisee with information, and that information only relates to pre-COVID figures, because that will not be a true reflection of what's happening now in the middle of the pandemic. And please keep also in mind, in terms of the Consumer Protection Act, a franchisor should provide the assumptions on which those financial projections are being made. On the franchisee side, I would recommend that the franchisee specifically request information from the franchisor in terms of trading pre-COVID and trading in the middle of COVID. So it will make a difference, because trading pre-COVID and trading in the middle of COVID, it is not the same. So the franchisee should be fully informed of what trading was before COVID, or if a business is sold now to a franchisee, the franchisee should understand the impact of COVID and how it may impact his business in terms of financial viability. It is also important that the franchisor considers additional cost in relation to COVID regulation compliance in its franchise projections and in its franchise agreements. For example, there are a lot of additional costs which a franchisee may need to incur as a result of COVID compliance protocols, sanitizing, additional staff appointed to ensure compliance, or COVID marketing material, COVID notices. All those kind of things, additional PPE, all those things may have a cost implication. So those additional costs should be factored in when a franchisor provides a new franchisee with financial projections, and if the franchise business is being sold or the franchise transaction is being entered into at this point in time during the pandemic.
Thank you, everyone. That's all we got time for today. Let us know what your takeaway was by posting it in the comment box below.
If you have any questions or you want to ask Esmari a question, you can pop your question either in the comment box below, but we will also be including a link to be able to contact Esmari Jonker of Smit and Van Dijk.
Also, if you found this session valuable, please hit the like and share button and share this with your network or someone you know who would be interested in learning about franchising or business in general. In closing, FASA is a non-profit organization that is there to protect, lobby, promote, and develop ethical franchising across all sectors in South Africa with a specific focus on transformation. If you would like to know more about FASA and its members, its memberships, as well as franchise opportunities and franchise surveys, please visit www.fasa.co.za. FASA also hosts regular online events if you are interested in owning your own business and being your own boss. Have a super day further, whatever it is you're doing.